So welcome to everybody. Today, GIZ Fabric is hosting two experts who are going to discuss the possibilities of arbitrating for fair purchasing practices. My name is Stephen Frost. I'm your moderator today, and it's my pleasure to welcome you on behalf of GIZ Fabric. Everyone attending this session today has either read or heard about or experienced firsthand situations where fashion buyers have refused to pay agreed upon prices for work completed. Having absorbed all costs up front and then to discover a client expects a heavy discount or refuses outright to pay at all is a blow for any company. And for some companies, it has been fatal. But even for companies able to absorb the financial burden of non-payment or heavy discounts, the bitter aftertaste of a client refusing to pay may linger long after cash flow or other financial problems have been overcome. Loss of trust and the resultant weakening of relationships are also common outcomes. And a common complaint among producers, apart from those already mentioned, includes a belief that there are limited options for recourse when these things happen. Where does a manufacturer in Asia turn when a brand or retailer in North America or Europe withholds millions of dollars already spent by a manufacturer? Today, we're going to tackle this question, and I'm thrilled to have two panelists with a lot of experience to take us through it. But before I introduce them, just bear with me for a few minutes while I go through some WebEx platform stuff for newcomers. I know most of you are probably familiar with Zoom or other platforms, and certainly if you use Zoom, I think WebEx is pretty easy for you to work out. But just let me invite, if you would like, to turn on your camera. I'm not telling you you have to, but if you would like to. If you do turn it on, you'll see a button for layout in the top right-hand corner of your WebEx platform. And we suggest you set your layout to stack or side by side. And we ask you to do that because it can sometimes be disheartening for speakers thinking that they're the only person in the entire internet universe talking into a blank screen. So seeing a couple of other faces on the screen can be a little more rewarding. And then just a few housekeeping issues. I need to tell you, first of all, that this event is being recorded, and the recording will be made available online. If you've attended, if you've signed up for the event, you'll receive an email with a link for that recording in the next couple of days. Second, all attendees are in listen-only mode. That is, we don't have a live mic, so people just ask questions. But you can ask questions. If you want to ask a question, please type it into the chat box or the comments box, and I will try and get through all of them either during the discussion. So if you've got a question that I think is pertinent to the discussion, I'll try and weave that in as we're talking. If I can't do that, we'll come back at the end for a Q&A session and try and get through as many as we can. In previous events, we've been able to get through most or sometimes all of the questions. The third thing, the last thing before we get on to the panel is we do have short survey polling for this event at the end. The IT guys will put a link into the chat box. You can just click on that link and it takes you to a very, very short survey. That survey is really helpful to us. It helps us make these events more relevant, more useful, more interesting for participants. So if you've got any feedback there, it is really useful for us. I will remind you towards the end of the event when the link goes in, if you could just take a minute to do that. So let's get down to business. We've got two panelists. The first panelist is Ben Van Pepperstreet, a garment policy advisor at Tradecraft Exchange. Ben wears several hats. He's policy advisor hat at Tradecraft Exchange is just one of several quite closely related hats that he wears. You can read his bio in the invitation. I won't read the whole thing out, but I think the important thing is that Ben's had a lot of experience where labour rights, human rights, international trade, and the clothing sector come together. So there's a lot of there's a lot of things coming together there where Ben has spent a lot of years working on. He's had a lot of involvement in the Bangladesh Accord on fire and building safety, so understands very much what's going on in the supply chain, and we're very interested and lucky to have him on the panel today. The second speaker is Patrick Miller. Patrick is the founding attorney at P. Miller Legal Services. And once again, you've got his bio, but I think the really important thing about Patrick is that, number one, although he's based in California, now he's spent a lot of time working in Asia, in Southeast Asia, for an international law firm on issues like commercial disputes. He's also a lawyer with a concentration in arbitration, mediation, and litigation. And that really brings us into the point where I think we can depart on this panel today. Patrick, I've just said you're a lawyer working internationally on arbitration, mediation, and litigation. I know you're based in California, but I also know that many of your clients are based around the globe. So you're really working on these issues globally for clients based in Asia, in Europe, all over the place. So this is not just about American-based issues. So getting back to this arbitration, mediation, litigation, that's three things you do. So I thought it might be useful just to start off asking you to tell us what's the distinction between those three things, between arbitration, mediation, and litigation.
Okay. And thank you, Stephen, for the introduction, and thank you all for attending. I hope I will give you some good information as we go through. And I think you summarized it pretty well, that I spend my time working on commercial disputes, so breaches of contract, be they verbal contract or written contract. But when there's a commercial dispute between a buyer and a seller in an international context. So when a commercial dispute arises, the first natural tendency would be to begin negotiations at the operational level and maybe at the executive level, try to come to some terms that you can find agreeable and resolve the dispute before it really gets to a head. Usually, if that's not effective, then you would want to involve some lawyers to give you a bit more representation and guidance on how to go about the process more. The first step to kind of escalating the dispute resolution process would be to initiate a mediation regime. So mediation is where you have a neutral mediator that facilitates the negotiated dialogue as between the parties. The mediator doesn't issue an opinion or come to any conclusions on their own. They just facilitate the dialogue. And the thing that you want to remember about mediation is they're generally effective only when both sides are prepared to compromise. So if both sides are willing to give a little bit, then the mediation might be effective. They're particularly helpful in contexts where the two parties want to continue their commercial relationship after their initial dispute. Oftentimes disputes can happen. You just need somebody to help facilitate the resolution of that dispute, and then you can move on forward without the types of breaches of trust and the acrimony that can arise in a longer standing dispute. So that's mediation in a nutshell. It's less costly and less time consuming. Then there's arbitration and litigation, and those are kind of two halves of the same coin, where at the point where you're doing either arbitration or litigation, you're in adversarial proceedings. They're much more formal and they're much more contentious. So at the point where you're initiating arbitration, it's much more likely that the the relationship can't be mended as such, and that you need a third-party arbitrator to come and decide this person is right and this person is wrong, and because they're right or because they're wrong, we are entitled to such and such damages. Now, the main differences between arbitration and litigation is that litigation happens in country courts that are presided over by governments, whereas arbitration is an informal, well, I shouldn't say informal, but it's a dispute resolution process that's administered by arbitral institutions. These are private bodies rather than national courts. So some of the key differences between arbitration versus litigation is that in arbitration, there's limited discovery and there's limited kind of pre-hearing motion practice, which means it's a bit more efficient than traditional litigation in courts. That helps to save time as well. You also have the access to expedited proceedings, which in a nutshell, if you have a relatively smaller value dispute, say $2 to $3 million, you can have that resolved in about 6 months to 9 months, depending on which institutional rules you're using. And the more efficient process and the quicker time results will also result in cost savings for you from legal costs perspective. One other interesting feature about arbitral awards rather than court awards are that arbitral awards can be enforced without access to many avenues for appeal. So you can actually have your award and get it enforced a lot quicker than you would a court decision. And arbitral awards are enforced through a binding treaty process called the New York Convention, where treaty signatories will honor arbitral awards issued by arbitrators as if they were national judges. And then litigation is traditional court work. I think that might give you a bit of an overview, and I want to give Stephen a chance to focus on something.
Yeah, that's nice. Just one question on treaty signatories. Can you just explain that a little bit? I mean, how many signatories are there to this to the New York Treaty?
There are about 150 signatories. So I'm sure all of the countries that we have represented here today are members of this treaty group. There are outlier countries that might not be members.
Yeah, got it. Okay. So am I right in thinking then that through mediation, arbitration, litigation, we're going up in cost? Is that roughly correct?
No, what I would say is arbitration and litigation are in their own sphere. Mediation is a relatively shorter process. Maybe that could cost 10 to 15,000, whereas a litigation or an arbitration, those costs range between, a rough general rule would be maybe about 5 to 10% of the amount in dispute will be the cost. So if you have $1 million, if you're suing to try to recover $1 million, it might cost you $50,000 to $100,000. It will much more likely cost more in court than it will in litigation, but not double.
No, understood. I can't ask you for exact prices, right?
Yeah.
So we've got, on the call today, on the, on this event today, we've got a number of producers, manufacturers in Asia. Can you take us through the arbitration process from an Asian manufacturer's point of view? What are the key things you should know about if you're thinking about embarking on the arbitration process? So, you've already determined mediation isn't going to work or it hasn't worked. You're interested in taking and beginning arbitration process. What do you do?
Okay, and don't let me forget to mention the opportunity to obtain litigation financing when we're considering costs.
Yes,
we can talk about that a little bit later. Just in general, what you have to first do is determine whether or not you have an arbitration clause. So that's an agreement as between the two parties to take their dispute to arbitration. Either you have that in your contract, or you might have a reference to trade rules, which which they incorporate arbitration. But at some point, both parties have to agree that they want to have their dispute arbitrated rather than going to court. If you don't have an arbitration agreement, what you'd want to do is identify a lawyer in the jurisdiction where your respondent has assets. So if you're suing a California company, you would contact me and I would file in California court a relatively straightforward complaint. But if you have an arbitration clause, what we would do is we would initiate an arbitration. That's by filing a notice of arbitration, which is kind of like initial complaint that sets out the basis for why you're claiming damages, what the breach of contract was, and how much you should be entitled to recover. And after you file that complaint and you initiate the arbitration, you impanel the arbitral tribunal. There could be one arbitrator that's going to decide, or you might have 3 arbitrators that decide. And depending on the contractual arbitration agreement and the rules that you use, the arbitral institution might appoint the arbitrator, or the parties might appoint one arbitrator each, and then the 3rd arbitrator is appointed by the other 2 arbitrators. So for the first stage is you initiate the arbitration, you send your notice of arbitration, then you impanel the tribunal, then you agree on a schedule for how the dispute will progress. There'll be a series of legal submissions where you set out and detail your case. They respond. You provide witness testimony in written form where you explain the facts of your case. You provide any expert evidence if necessary. Then you would have a hearing where the arbitrators can actually see the witnesses give their evidence in person and be cross-examined by the other side's attorneys. That's why it's an adversarial proceeding. The adverse party cross-examines and tests the evidence. And after all of these submissions, legal submissions, evidence submissions, all of that is put before the arbitrator, and they'll issue an arbitral award. Once you have an award, you would then have to enforce that award. An award itself is just a piece of paper. What you need to do is you take that award to a court where your debtor has assets, and you say, pursuant to this award, you please order a bank to give this money, or order this person to give this money, depending on how you're enforcing it. But you have to go to the jurisdiction where the assets are. And so that's generally the process. One point is that in the context of expedited proceedings, that process can be much more constrained to about 6 months. There generally isn't a hearing held where witnesses give testimonial evidence. It's mostly just all on documents. If it's a more traditional process, that could take about 12 months.
So let's dig into this a little bit. Let's say I'm a manufacturer in Bangladesh, and my UK client, based in London, has refused to pay for work completed.
Yep.
So I've got stuff sitting in a container, they're refusing to pay, etc. So do I need to find an arbitrator in Bangladesh? Do I need to find an arbitrator in London? Can I go to California? What's the situation there?
Yeah, that's a good question. So it's really not location specific that much. So arbitration is kind of trans global in the sense that your arbitration agreement might specify that you'll have an arbitration that's located in, say, Switzerland or Singapore, but you don't actually have to have that hearing in Singapore. It's just that's determined to be the situs of the arbitration. Many arbitrations these days are held via Zoom or other remote communications, so you don't have to find an arbitrator that's any specific nationality. You can determine in your contract which law applies. You could be a Bangladeshi manufacturer working with a British client and decide that you want to have an arbitration in Singapore under Hong Kong law. And so you could appoint arbitrators from around the world. They might be in Europe and Asia, and they would be applying Hong Kong law. You'd have a lawyer like me who'd be in California making submissions on Hong Kong law to arbitrators, based in the Caribbean or Europe or wherever, and then they would issue a decision, and then you would go and enforce it probably in the UK, because that's where you'd assume they'd have assets. But if they're a global company, they might have assets in many jurisdictions. So does that give you a sense?
So a Bangladesh or an Indian or a Cambodian manufacturer then has the ability to request an arbitration clause in a contract that they would, in ways that they would see fit.
Yes, exactly. So there's dispute resolution clauses the same way there's payment terms clauses and quality clauses. There's general clauses that say if we have a commercial dispute, we will resolve it through arbitration. You can specify the type of law you want to apply. You can specify the number of arbitrators, the institution that you want to use. If you want to use a Singapore institution or a British institution, that doesn't really matter. Most of the institutional rules are roughly similar. And to be honest, most commercial law is roughly similar. So the idea, if you wanted to be intransigent and say it has to be Bangladeshi law, I would often advise that that's generally not necessary. You'll be just as fine applying UK law, because it's just going to be a commercial arbitrator. It'll be an international arbitrator, could be from anywhere, and they'll just be applying English law principles. And I would expect that most Bangladeshi commercial codes are based on English commercial codes anyways.
Yeah, I'm not an expert in that. I don't know whether to say whether that's true or not. Maybe someone in the audience knows something about that. But I think you've answered a question that someone asked in the chat box. I don't know if you can see it, about, do manufacturers need to know which is the most beneficial law, or there is no big difference? I think what you're saying is that there's no really big difference. Is that right?
In the context of commercial laws, I mean, I don't know every single law in particular in the context of a supplier relationship, but in general, they're similar. What you might want to think about is whether there are supplier trade union rules that are in effect, which have specific rules related to payment terms, related to what happens if a buyer breaches. So rather than simply applying English law or Bangladeshi law, you could apply the trade rules, which you might think are more favorable. So we're talking about developing an arbitral system that addresses responsible purchasing practices. The first step might be agreeing as a community of suppliers what are some key responsible purchasing practices that we want to say are industry standards. And so then you apply the industry standards to your dispute.
What about the case? One of the things if we go right back to your very first words, I wrote this down. One of the first things you said was you do a lot of work with commercial disputes, whether there's verbal or written contracts. So let's just jump forward a bit. What if a business is doing business on the basis of verbal orders on the phone? I want 100,000 t-shirts.
Yeah.
Where do you stand if you made 100,000 t-shirts and then you get another phone call saying we're not going to pay? Mm. Where do you sit with arbitration in that sort of situation?
So there are a lot of nuances to that question first. So let me I don't think I gave the typical disclaimer. I'm obviously not giving legal advice in this context. I would have to understand exactly what countries you're working with, what laws might be applicable. But in very general terms, you don't have to have a written document to have a contract. You can have a verbal agreement, and the evidence that you have an agreement is the fact that you went and did that. And if you have a course of conduct where you regularly take phone orders, you regularly manufacture the product, and then you regularly ship it 2 weeks later, and then they pay you two more weeks later, and that's happened several times, you could say that our demonstrated conduct shows that I expected him to pay me 2 weeks later after I manufactured these goods. So you don't necessarily have to have something in writing to have a contract. And you could even go to a court, say in the US, and say, this is our course of conduct. This is what we've been doing. This is our verbal contract. And I want to claim damages based on the verbal contract that we had. With respect to arbitration, there almost always is a requirement that they be in writing. So if you have a verbal contract, you probably won't be able to resort to arbitration, but you can still resort to court work where you would go and sue them in the court where they're located.
Yeah.
You could sue them, you could sue them in Bangladeshi court, for instance, based on that contract, but then you'd have to take the Bangladeshi court judgment and then go to the UK and enforce the Bangladeshi court judgment, and then you might have to re-litigate some issues of it depending on the circumstances of the dispute. So oftentimes it's more advisable to just go get the court judgment in the jurisdiction where you'll be enforcing it. But that's 20 years ago, that might have been difficult, but nowadays with international communications and international lawyers and smaller boutique firms, smaller companies are able to hire law firms like mine that don't charge exorbitant fees and don't need to have massive international footprints to be able to do this kind of work. And I did want to mention the access to litigation funding. It's a very important subject, particularly in the context of smaller scale suppliers that don't have the legal budget to pay sophisticated lawyers. What litigation funds do, they're private equity companies that seek out claimants that have good, strong legal claims against, solvent respondent parties. So if you were a small company that had $1 million or a $2 million claim against a large company in the UK, they would be happy to fund my legal costs. So they would say it will cost $100,000 to bring this claim and to get your $2 million award. You have a very strong claim. We expect that you're going to win it. You have good legal counsel. We expect that they're going to do well, but you need to be able to pay them about $100,000 over the course of a year. We understand you might not have that budget. We will give you a non-recourse loan for $100,000, and in return, we would want a portion of that $2 million award. This is a phenomenal new resource for smaller companies to level the playing field so that they don't have to take suboptimal solutions in the way they used to have to.
Where, once again, if I was a manufacturer in Asia and I was listening to this with some interest, where would I find those private equity firms doing this kind of investment?
So what you would want to do really is you would want to go to a lawyer first, because so I know of 25 different litigation funding companies, and I know some litigation funding companies that specialize in different geographic regions, some litigation funding companies that specialize in arbitration or litigation, or there's different niches for the different companies. What you want to do is you want to have a lawyer approach the litigation funding companies, because we act as kind of the first line of analysis to ensure that the claim has merit and that the claim would be attractive to the litigation funder. So if you're in a situation where you have a company that's not paying your bills, you would give me a call. I would spend a couple hours looking through the facts of the case, looking through the specific legal nuances, which countries are we in, what law might apply, do we have an arbitration, do we have a litigation, all of those different things. We'd spend a few hours working through that, and then I would write a kind of memorandum proposal, almost like a pitch to the litigation funds to say, they have a strong claim, they're good claimants, I believe in this case, I expect it will take this much to prosecute the claim. These are the terms that we would like to work with. And I'm doing that right now with clients.
Yeah, I was absolutely fascinated when you told me about this on an earlier call. So that's definitely one avenue that's out there that I wasn't aware that it existed.
It's
Okay,
a really
look,
incredible avenue, and I just wanted to say that I believe I sent my my web link to my website and my email address. I'd be happy to take a call from suppliers who might want to just talk through this a bit more in detail in their individual situations to really set out whether or not this would be something that could be useful for them. And just to add, I've been talking to several litigation funding lately about this call I was going to have, and a couple people had mentioned that they'd been surprised that they hadn't seen as many claims arising from the pandemic coming from suppliers in the developing world. They're surprised that they haven't seen as many claims so far.
interesting.
Yeah.
Okay. Well, there's a message there. Make of it what you will, everyone on this call. I do have one question here. We'll finish just on this question, then I'll turn to Ben. Lucy Brill from Home Workers Worldwide has asked, what about force majeure clauses? I understand some brands try to use these clauses with respect to COVID for non-payment, etc.
Yeah, I mean, certainly, so I've been involved in some arbitrations already where force majeure was an issue. Force majeure is not a get out of jail free card. Force majeure requires strict regimens, strict proof that says for this time period, you cannot overcome the force majeure issue. But often what's happened in the pandemic is that time period has passed. There might have been a month where you absolutely couldn't overcome the issue, but after that, the time passed, and then you go back to the contract. You don't just wipe your hands clean because of force majeure. It's for discrete acts. If you told me that your counterparty was in Ukraine right now, I would say they probably would have a strong force majeure claim that they're not going to be purchasing T-shirts for the time being, that you can't ship them through. That's one thing. But I mean, the pandemic was 2 years ago.
Right. Yeah. There's been quite a lot of commentary on the force majeure clauses. There's another question there, but I'm going to come back to it maybe in Q&A because I do want to get to Ben.
Yeah. Sorry.
No, that's great. So I think what Patrick's given us is a very clear and succinct overview of where arbitration fits in a range of options open to businesses that feel they've been on the wrong end of purchasing practices. I want to shift gear a little bit now and turn to our second guest, Ben. Now, one of the reasons we invited Ben on, not the only reason, one of the reasons we invited Ben on is because he's had a lot of involvement with the development of the UK Groceries Code Adjudicator, which is an independent regulator ensuring that regulated retailers treat their direct suppliers lawfully and fairly. So the last part of that description of the UK Groceries Code Adjudicator about treating suppliers lawfully and fairly should resonate with many of the people sitting in on this call. Now, I don't want people to get sidetracked by the fact that we're now going to go and talk a little bit about the Groceries Adjudicator, the UK Groceries Code Adjudicator, because getting back to the reason, one of the reasons why we invited Ben on is because is there something that the fashion industry, particularly brands that want to see these practices stamped out, and suppliers that obviously want to see these practices stamped out, is there something that we can learn from what happened in the UK with the grocery supply chain? But I should also point out that Ben and Tradecraft Exchange have been working quite a lot themselves, I'm thinking, what lessons can we learn and apply to the fashion industry? So Ben, just to be shifting gears, Ben, can you give us a little bit of background of the development of the UK GCA, and then maybe we could get onto a discussion about what this tells us for the supply chain for fashion.
Yes, with pleasure. Thanks, Stephen. And also, first and foremost, thanks to GIZ for organizing, bringing us together in this intimate setting. And also thanks to my co-panelists for giving such a primer on non-judicial avenues for disputes. So the UK Grocery Code Adjudicator, and actually more largely because this instrument has been mirrored and developed across the European Union, because there was once a time that the UK was a member state of the European Union, and just before yes. Brexit, they managed to mainstream the system. Because notably what both in the UK and actually at the level of the EU, they they noticed is that the agricultural supply chains are marked with a very severe power imbalance between the buyer, the supermarket, and the farmer or the supplier. And that resulted in no longer really in a functioning of the market, so that the buyer would actually be in such a powerful position that he or she or it could dictate all the terms. And even then later on, when the terms that the buyer would have dictated, which already, if you can dictate the terms, you of course dictate them in your own favor. But even then, when they would, the situation would unfold in such a way that those terms would not work very well, that even then the buyer could do whatever they want and change unilaterally the terms to see it fit to the adapted situation. And then the suppliers, in this case the farmers, would often not even dare to seek recourse, judicial recourse or non-judicial recourse, etc., because not so much because of financial and legal hurdles or complexities of transnational litigation, but just for the mere fear that they would be losing an important client, because we're again talking in a context of market power. And I think that's very important to realize as a start, because if I explain this situation and I would have replaced supermarket and farmer with retailer, garment brand, and garment manufacturer, we would come in exactly the same position. Exactly, that's even what the ILO has come to a conclusion when they went and looked at market power in supply chains. They found, of course, very big power asymmetries in the agricultural sector, but the worst sector that the ILO surveyed was the garment sector. So that's why a lot of indeed the thinking there is going to be useful here. And so I think the UK Groceries Code Adjudicator, as well as the rest of the European system under the 2019 Unfair Trading Practices Directive, have two main components, and I think they're both very important. First and foremost, they set a sort of code or a statute of norms. So they limit a bit the freedom of the two parties to negotiate a contract. You can still negotiate a contract in every way you want, but within certain parameters. Because also in part, both in the agricultural sector as well as in the garment sector, let's be honest, there is not always that much negotiation. A lot of the modalities, a lot of the terms are unilaterally dictated by the garment brands and retailers, so they're contracts of adhesion mainly. The only thing you can talk a bit more is maybe quantity, price, lead time, but even there, you're a bit squeezed. But let alone that manufacturers can start debating oh, I want this clause inserted into the contract. I want that jurisdiction. I want to reference this particular industry standard as a way to supplement the contract. That kind of bargaining power simply doesn't exist here. And that didn't exist in agriculture either. So that's why in the agricultural sector, they said, okay, let's at least have a list of key elements that we certainly need to see everywhere, and that is a list of what they call forbidden practices. So what does this entail? It is, for example, saying like, well, you need to pay within 60 days after delivery. Again, I think if I say payment within 60 days after delivery, for lots of garment manufacturers, that would seem as a very attractive proposal, given that in the garment supply chain, we've now seen payment terms up to 120 days after shipment, 160 days even, although that's maybe a bit more rare. So that's half a year. So what the both the UK groceries code adjudicator as well as the European directive say is, well, no, it needs to be paid within 60 days. If you want a contract, you need to, there needs to be a written contract. If there are unilateral changes at the last minute, that needs to come at the premium. You can't just do that, just ex officio. So those are all a bunch of elements in the code, which otherwise suppliers, in this case agricultural suppliers, but also garment manufacturers would not be in a position to reasonably insert into the contract. So that's the first box, like what are the rules itself, and it's very important to keep that in mind. The second thing is that they indeed came with a system of dealing with complaints through a regulator. So the processes that Patrick described are all adversarial. And so the first things about an adversarial process is you know who your opponent is, because often it's the opponent who initiated the proceeding to start with. You have even a right to know who is accusing you of something. Both in the agricultural sector and also in the garment sector, this is the quickest way to make sure that client stops doing business with you. And that can be for a lot of enterprises, a lot of problems. So for example, we recently did a survey together with Aberdeen University, together with Brack University in Bangladesh. We surveyed 1,000 manufacturers. So that's a lot. That's a significant portion of the Bangladeshi garment industry. And a large chunk of them had one or two clients. So if you then have only one client or two clients or even three clients, then going into open court against one of your clients might actually just mean a reduction of 40% of your business, which already is under pressure of those unfair trading practices. So that fear factor needed to be addressed in a different enforcement strategy. And that's where a regulator came in, where suppliers can make an anonymous complaint. And in that sense, then the regulatory body goes and checks, goes, for example, to the buyer, let's say, Marks and Spencer, not that I have a beef with Marks and Spencer, but just to give an example. Full disclaimer here, that's, or it could be any other, but that then they would say like, okay, we have a reason to believe that something is going on, that you are violating this code. Let's check. And if that would be a problem, then indeed Marks and Spencer would need to correct its course, etc. And that would then benefit again the suppliers of Marks and Spencer. Again, no beef with Marks and Spencer. This is a purely hypothetical example. But Marks and Spencer in this case would not know which is the supplier that complained, and so in that sense couldn't retaliate against the complainant. And I think that's a very crucial element that we also need to bake into the system here. And so what we've now seen after like a decade of experience in the UK and also across Europe, you already saw these formalities in the agricultural sector come up, like for example in Hungary, etc., and in Belgium. That after a decade, we see actually a vast difference, especially in the and there it's quite interesting in the buyers who buy both food and clothing, because there it's interesting to compare what they're actually doing. And there we see that buyers who are like multi-product do respect the groceries code or the 2019 unfair trading practices directive in the agri-food sector and have payment terms for 30 days, 60 days exceptionally. But then when it comes to the unregulated part, namely the garment part, there we see payment terms of 120 days, 160 days, etc. So you even see the same company, part of their business is regulated and they adhere to the regulation. The other part is unregulated, and that's why there they can do whatever is doable and use that market power that they have. So that's why we're very happy with the Groceries Code Adjudicator and the Unfair Trading Practices Directive in the EU. But that's also why we think that this strategy or parts of this strategy are going to be extremely useful also in the garment sector to empower and rebalance a bit the power asymmetry between manufacturers and brands and buyers.
Ben, in the chat box, Kim's asking, does the anonymous mechanism already exist?
Well, as I said, it exists in agriculture. So that means that, and it does not exist in garment yet. It just means that it can exist in the future. So that's why we're advocating for it. What we do see is that sometimes some countries in Europe have transposed this agricultural UTP directive a bit broader. And the one country that has transposed it across the economy, so all sectors, including garment, is Estonia. Problem is that Estonia doesn't have significant brand and clothing buyers, so that's a pity there. But so I would say not really.
Right. So Kim's had a follow-up question, and I think probably other people on the call are thinking this too. What how did this system get enabled in the grocery sector? You know, what was who were the drivers? What actors were driving the development of this? And then I think, you know, the question that arises from that, once you've talked about that, is, well, what are the lessons to be shared, you know, in working out who the actors were, how did it get developed?
Yeah, well, one of the big drivers of that was actually the producers, suppliers, the farmer sector. They themselves were complaining, okay, we're getting squeezed, we are at the so-called bottom of the supply chain and all this pressure comes above us and we're paying it, and our businesses are not necessarily profitable either. So of course some divergence within the sector. So there was a big call of it within the sector itself. And currently we haven't seen such an explicit call in the garment sector yet. Again, that might be something to come, but currently there's not such a big alliance of manufacturing associations who say this is what we want. European Union, start regulating your buyers, because that's where the problem is, notably because of the power asymmetry. The other element was data. Although I do think in the garment sector that data is not necessarily a problem. It is there, it's maybe a bit scarce sometimes, but there is the ILO study that I mentioned about supply chains across sectors. That's of course a first overarching view. but also the Commission in its first documents preparing to the 2019 agricultural UTP directive in agriculture had also done a broader survey, and textiles was one of the sectors at that moment considered. But they went first for agriculture because that they thought was a bit more straightforward. And then I think with the recent COVID crisis, I think we also saw much better data coming out of so-called producer locations. So I understand that, for example, Professor Mark Anner has worked with the BGMEA in Bangladesh to visualize the problem there. Me, in another hat, I've also done a study on the use of force majeure clauses. I also know about, for example, in Vietnam, that there's actually pretty good research being done on documenting the problem. So there is left and right quite some research being done on documenting the problem, but it is not necessarily translated yet in such a political demand that, let's say, you go to an OECD panel that everybody is asking for this. But
well, let me go back to
brands
something
will
that you
certainly.
said.
Yeah, sorry.
Sorry, Ben. No, go on. Sorry. Continue.
I was just going to say, but one group that will, of course, not ask for this are brands and retailers, because there's not a single company that says, I want to regulate myself. So that's a corner that we don't need to look for.
Yeah, okay. All right, we can strike them off. Let's go back to farmers. You said, so I asked about the actors driving this, and you said farmers. When you say farmers, what do you mean? Are you talking about farmers associations? Is this at a national level? Is this, can you just expand on that a little bit more? And Lucy in the chat box has asked a question that I think is related to this. And she says, "Look, farmers have access to tractors and muck, fertilizer, cow manure, et cetera, so they can cause significant disruption. And in the UK, they've also been mounting an effective public campaign." So I'm just thinking, when you say farmers, what are we talking about? And how does that relate then? Yeah, how can you then relate that to manufacturers across Asia or Latin America, et cetera? Is there any learnings there for us with the farmers?
No, this is a perfect question. In the sense, I think the farmers comparatively had two advantages. A, the proximity, and because there are lots of farmers in Europe. You could also argue there's quite some garment production in Europe, in South Europe and Eastern Europe, but again, they haven't politically mobilized themselves. And that's, I think, the other advantage farmer groups have. Like, they're very well organized, and they indeed have the ability to, as Lucy rightfully says, for example, I live in Brussels. I think it's quite regular to see farmers come to European Commission and then dump 2,000 liters of milk in front of the Commission building. And those are very disruptive, violent actions, which makes that, if you're a politician, you don't want to make farmers angry. At this moment in time, if you're a politician, at least in the EU bubble, making garment manufacturers in South Asia, Southeast Asia, East Asia angry doesn't give much political repercussion yet. So it's quite fine to anger them from a politician perspective. Yeah. So, but that's of course farmers using their specific place and advantages. I think the question is more, first, I think garment associations need to first think about which is the policy solution that we want. And once you have that North Star, that compass, they need to think about in their own way on what is the best political strategy forward to achieve that goal. And so for farmers, that is to go to Brussels and then dumping manure in front of the Commission. For garment manufacturers, it might be another way.
Right. Yeah, and I think
like manufacturing really ugly sweaters or something like that.
Yeah.
Would be
talking
innovative, at least from a
sweaters.
lobby and advocacy strategy.
Yeah. Now that's so. What's the Tradecraft Exchange position on this now? Because I know Tradecraft Exchange has been, thinking and talking about what do we do in the fashion supply chain. Where are you now on this on this question about what the industry needs to do?
Yeah, so I think maybe also based on what I said earlier, that we have come to the conclusion that a similar system, it doesn't need to be exactly a copy paste, but a similar system of saying like these are boundaries to curb a bit practices of the buyers. Together with a system of enforcement that can receive anonymous complaint, now to deal with the fear factor of enforcement, which I think is also what Patrick alluded to, is very surprised that there's so little complaints in contrast to so many breaches of contract. So that double system is really what we're advocating for. And we are in a position currently trying to seek as many allies on that, because like any policy change, it doesn't happen overnight. Policy is slow, but if you are insistent and constantly bang on the same nail, there is a pretty good chance of success. So we've been in the last years speaking with whomever wants to speak to us, including here. So again, thanks for inviting us.
Yeah.
About who wants to join this coalition of the willing moving forward. And so there is some appetite. We notice in the Brussels bubble, we notice also with some manufacturers that we speak to. We also speak with, of course, policymakers. We don't have the impression that in the European Commission, this is really a political priority now. And in the discussions that we've had so far, at least in the Justice Department, they seem to understand the problem. So they're like, yeah, no, this makes sense. A, the problem, and B, the approach. But it doesn't seem to be a political priority. And in Parliament, the European Parliament, we seem to get a bit more visibility on this topic. But again, I would say we're just at the beginning of what could be a process for policy change.
When the UK Groceries Code adjudicator was being developed, or even now that it's developed, what's the percentage of supermarkets that are would be regarded as regulated retailers? I'm asking that in a bad way, but I think you know what I mean, right? Like, of the percentage of grocers in the UK, how many are regulated under this adjudicator?
Well, so I'll be very embarrassed because I don't know the percentage, but what I can say is that it starts regulating supermarkets from a certain size. So you have most of the main. So that means bigger ones are regulated, which also makes sense because it's the bigger ones that have the market power. It's a client that can supply you with orders for like years and years and has like 150 suppliers who it pits against itself, that has market power. It's not a small supplier that is really causing the problem both at the individual level or at the systematic level. So yeah, it just covers big suppliers. Sorry, big buyers.
Yeah, right. Okay. And then just one final thing, and I can see quite a few questions mounting up in the chat box. Don't worry, I'm not ignoring you if you've been diligently typing things in. I have been watching, but we'll get to them in the Q&A. But the last kind of question I want to ask on this, Ben, is, so what's been the effect? Has the GCA had a positive effect on purchasing practices?
Yes, it has, and we can clearly see that. So the GCA as because that's the one that we know best. But again, across Europe, there's a system of regulators. We see has taken two approaches. One, to proactively prevent, so to speak with all of the supermarkets, to say this is the code, explain the code to it, this is what you need to do, this is what is best practice, etc., etc. So really try to convince. And then in second stage, use the stick, either because it wanted to do an investigation out of its own behest, or because there was a complaint. And that sort of like stick and carrot approach seemed to work. We see that some of the other regulators are a bit more stick, like the Hungarian regulator. It's just consistently issues fines. Although it's weird because those fines tend to be relatively low, and you always see the same companies being fined. But what you see in the UK is that it drove up the purchasing practices to what you could call a quality one. So especially on the level of payment terms, I already explained the difference. Those multi-product retailers being actually quite good when it comes to groceries, paying within 30 days, paying sometimes within 60 days, and in garments and paying in 120 days, and it's essentially the same buyer. Also on planning and forecasting, it has improved a lot, which also again in the garment sector is really an issue. And on the order confirmation, volume, etc., it also improved significantly. The one issue where it's maybe a bit less stringent, although that's maybe a focus moving forward, is of course price points. Because that remains always an issue. What is really a fair price? But also there, apparently there is noted improvements, but I can't really, I don't have the data to compare those unfair trading practices in the agricultural sector towards what is happening in the garment sector.
Who pays? How is all of this funded?
Well, so each system has its own way of funding, but often it's just general funds of the EU member states and the UK. But it's relatively lightweight. So we're talking in the UK about one adjudicator, so that's a person who's nominated by the government, and he has quite a skeleton staff of like a handful of people to support in that work. But I think what is maybe more, which is for like an average EU member state, is not a significantly big department. What is maybe a bit more important is that it does have the power to compel documents, to say to a retailer, well, show me when you paid. I want to see all transactions and I'm going to analyze them. Or show me your contracts. I want to see if they're in line, and I want to see your practices being in line with those contracts. So I think that's much more important, because a lot of the unfair trading practices that we're talking about, also in the garment sector, are very close. They're not based on not public domain elements, especially if you go beyond your own individual case. And so that power to open a bit the box of what is happening in the belly of the buyer is very important evidentiary wise, and then probably also a challenge in some of the more adversarial proceedings.
Yeah. Is Lucy right in the chat box when she says that she thinks that the big supermarkets in the UK also pay a fee to the adjudicator?
Yeah, that is specific to the UK system. Other systems believe more. Other states believe more in state power. So the mixture goes a bit across. So in the UK, it's fee based. Some member states also use the fines to finance themselves. Sometimes it's general budget.
Yeah. Okay. Got it. Yeah, okay. Look, this is fascinating stuff. I wish this session was longer now. All right, we've got a bunch of questions in the chat box, which I'm going to get to. The IT team have just posted, and I'll remind you now, please take a minute to fill out the feedback form before you leave. And there's a link in the chat box, asiandialogues.com. You can just click on that. That would really help us out. So I'm going to start with a question from Lisa, which was just put up a couple of minutes ago, because it fits in with what Ben's just been talking about. Are there plans to make these mechanisms sector spanning? Why only one sector? Power asymmetry is inherent in so many sectors. Have you got an answer for that, or is that a bridge too far?
It's a good question, and again, it depends on the power and the advocacy coalition that wants this. So if all of a sudden people manage to convince, let's say, the German government to expand its transposition in the agricultural sector to all sectors, then in Germany there would be an instrument. Same thing in Italy. So you need to push for it. And that's why we believe also that the European level is maybe an adequate level, because then you capture quite a lot of member states at the same time. But it's in essence really our raison d'être here.
Yeah. Okay, good. Kim asks, would participating in arbitration mechanisms be incorporated into due diligence legislation? And she says in brackets, in the sense that a brand agreeing to participate in an arbitration mechanism becomes a required part of their due diligence work.
So
Can be. Oh, sorry.
Yeah.
Yeah.
So you find those in the context of grievance mechanisms. So oftentimes you want to allow for stakeholder grievance mechanisms, so that way maybe an employee who's been a victim of human rights could have that grievance mechanism. In the context of arbitration as between the supplier and buyer, it makes sense that it could be in due diligence legislation, but I don't think that's in view of the proposed directive, the EU directorate. But I think Ben is probably better to speak to that.
Yeah, Ben.
Yes and no. So, well, first of all,
You sound like a
really
lawyer,
depends.
Ben.
Yeah, for full disclosure, I did have some legal training. But at this moment in time, it's just a proposal of the Commission to the other to co-legislators, the Council and Parliament, and there is some mentioning like on purchasing practices, and there is indeed a reliance on cascade contracting, but it is very unclear whether or not, at this moment in time, the language on purchasing practices is very soft. So it's certainly not as prescriptive enough to lead to the actual change that we want. And so this is why we like also the Unfair Trading Practices Directive. It doesn't say about your payment term needs to be in such a way that it should not impact negatively human rights, which is the due diligence approach. It just says, no, 30 days. It's very simple, very clear cut. And it becomes very clear also for people to interpret, even in an adversarial proceeding. It's very clear, you paid in 30 days or you didn't. Whereas the due diligence approach, seeing that your payment term did not contribute to adverse impact is open for lots of debate. So that's the first problem. And then this cascade contracting that is currently in the proposal is very unclear whether or not indeed it has any alternative dispute mechanisms in there. So are those only enforceable in court, or are they, as Patrick mentioned, contain an arbitral clause just to also make the proceedings a bit more straightforward, maybe some less, maybe more cost effective, maybe a bit more quicker, or are they working in a different way? We don't know. let alone what is the content of this contract in terms of payment, order amendments, etc., retroactive discounts. So it's maybe way too early to say, but I would just say at this point, I wouldn't necessarily bet my money on it yet.
Okay, understood. Lucy's got a question, which I think is you may have answered. Could the fashion watchdog proposal be included in the EC's sustainable corporate governance proposals?
Yeah, again, and I'm happy that the term fashion watchdog is picked up, because we were debating a lot whether we were talking about fashion watchdog or fashion police from a campaigning perspective. But apparently fashion watchdog sticks. Ideally, we would want to, but we also need to understand that the corporate sustainable due diligence proposal is a horizontal proposal. So it covers all sectors, ranging from IT firms to guns to agriculture to textile, and a lot of the challenges are different per sector, because a cement factory in Syria is a different case than a garment factory in Cambodia. So so we don't think we can go as far within this horizontal instrument. That's why we think maybe a more textile adapted instrument would work better, because it can really tailor to the needs of the sector. Some of the elements are maybe general, some of the elements are specific. And I think also Patrick already alluded a bit to that a number of these norms, you better deal with it at a sector level. So you have enough generality for everybody in the sector, but you also capture the specificity of the sector.
And I just wanted to add, one of the helpful features about arbitration is that it allows for the parties to nominate specialist arbitrators that have experience in the apparel sector. So you could have trade rules that are specified to the apparel sector. You could also have experts who could adjudicate apparel sector disputes, so they would understand the background knowledge, which is so useful in these cases.
Patrick, just going back to what you're talking about with arbitration in the first half, someone's asked in the chat box, what happens if an arbitration claim is not successful?
So it depends on the jurisdictional rules. In some jurisdictions, the successful party is also awarded their legal costs. So if you have a claim and you're unsuccessful, the respondent might be able to request that they be awarded their legal costs. So there would be that downside risk. Sometimes that's not the case. Even if you lose, sometimes you wouldn't be, ordered to pay legal costs, depending on the type of case it is. But once you have an arbitration award, and if it's against you, then you can't then go to court somewhere else. That it's a final award. So that's why you don't just want to initiate an arbitration on your own. You want to get counsel to do it properly, because you only get one shot at these things.
Yeah, we've got a question from Cambodia. Maybe this is for Patrick. Kavong Nor. In Cambodia, we have both commercial and labor arbitration, and they have their own websites where we can download existing arbitral awards. I have one question. Which website, I have one question. Could you tell me what websites are there where I can get access to download international existing written arbitral awards?
So this is actually an interesting topic, and I don't want to get too far into the weeds, but for a number of years, arbitration sold itself as being confidential, and so there was a hesitance to publish awards. It's only in the last 5 to 10 years where the institutions have realized that it's actually beneficial to have the awards published. So different arbitral rules allow for awards to be published now. Oftentimes, they redact the information of the parties or any confidential information. You can also make motions to request your specific arbitration to be not public for whatever reason. So I guess it depends on the arbitration. I'm not sure exactly what they're referring to. They might be referring to the Cambodian Arbitration Association, but that would probably be a relatively small arbitration association with quite few awards. There are much larger organizations, for instance, the Singapore International Arbitration Center. They host arbitrations from all over the world. And so they would have a much deeper repository of those. I guess the question is, are they asking as a legal practitioner for the purposes of analyzing the jurisprudence, or are they just interested in learning a bit more? I guess.
Yeah, this might be something that they need to have to follow up, more specialized.
Yeah, no, of course. We can talk after the chat.
Yeah, and we need to just remind people that Patrick's a lawyer, but he's not giving out legal advice here. This is a very general kind of discussion. But Kavong also has another question. Whoops. I have another question. Which laws are applicable for international arbitration? Is there a list of those relevant laws for applying for international arbitration?
So first, what happens is you look at the contract and you say, did the parties agree on a law? If the parties didn't agree on a law, oftentimes what you would refer to is what's called the CISG. That's a UN set of commercial codes that's agreed that it will apply to the international sale of goods when the parties don't specify a law. So oftentimes, if you don't specify it in the contract, the CISG will apply. That's international standards for sale of goods.
And maybe to add to it, because indeed, if it's not specified, it goes then by default to the law of the land of the manufacturer. However, if you specify it, it is whatever is specified. And so, as I said before, given that most of the contracts, if not all, are determined by the buyers tend to, in all the contracts that we've studied, to place the jurisdiction, both the jurisdiction and the substantive law, in where they're based. So for H&M, that will be Sweden. For CNA, Belgium, or Germany. Marks and Spencer, the UK. So that's something you see standard in it. That it's actually the jurisdiction that the buyer knows best.
Yeah, I was going to add, that's not necessarily nefarious. It's often just because the legal counsel for H&M is more familiar with Swedish law, so they're more comfortable with Swedish law, and they'd rather have that be included. But Swedish commercial code will still give you similar results to other commercial codes.
Alish Patajwa from Pakistan says, I've got a question from Pakistan. How can we deal with trade fraud? And in case of imports from Germany, would we require the embassy in Pakistan to step in for arbitration? This takes us a little bit out of our sphere here, but maybe there's a quick answer from Patrick.
Could you say it one more time, please?
How can we deal with trade fraud? And in case of imports from Germany, would we require the embassy in Pakistan to step in for arbitration?
So the embassy wouldn't have to compel arbitration. If you have a contract that has an arbitration clause, you would just initiate the arbitration. The arbitration clause would designate, say, the International Chamber of Commerce to handle the dispute. So you would just submit the notice of arbitration to the International Chamber of Commerce. The arbitration would be commenced, and you'd proceed with the arbitration. You wouldn't have to get the customs involved. In the context of fraud, sometimes you might argue that that's not a contractual issue that can be arbitrable, but that's starting to get in the weeds a little bit.
Enkakata Dan asks, what are the top 5 commercial arbitration firms, I presume, is what he or she is asking. I don't know if Patrick wants to answer that.
So as far as arbitration
question
firm,
of how do you choose your arbitration firm?
So,
Yeah,
so
right,
as far
yeah.
as arbitration law firms, there are some large, to just give a general answer as far as law firms, most large international law firms have arbitration departments or specialists that handle arbitration. But then over the last 10 years, a lot of those specialists at the international firms have joined boutique firms or opened their own boutique firms, and the benefit of that is they have a lot less overhead, they have lower costs, so they can work with small to medium-sized companies. So there's a wide array of different law firms that can do it. If you're asking what are the top arbitral institutions, so there's the ICC, that's the International Chamber of Commerce. There's the Hong Kong International Arbitration Center, the London Center for International Arbitration. There's the Swiss Arbitration Center, the Singapore International Arbitration Center. Those are some of the main ones, I would say.
Yeah, okay. We're going to finish off with this question because I think it kind of rounds off our conversation here and probably really gets us to the point of where we can do another seminar on this. Kim says, thanks very much for this information. Suppliers should collectively advocate for this as legislation is now being discussed. But practically, we do this? How could we as suppliers do this? We don't know how to feed into these processes. So, you know, for suppliers, you know, manufacturers sitting in on this call, what do they do now? What's next?
Well, it might sound a bit belittling, but in essence, good lobby is just convincing policymakers that your solution is better than what is currently on the table. And if you think from there, everything and nothing is possible. So you can either do like the farmers and say, if you continue with this, you will have this every week in front of your door. As we've already established, garment producing or manufacturing associations are not necessarily in the same position to do so, but you could still do lobbying and advocacy. There is currently, an active proposal, the Corporate Sustainable Due Diligence Directive, on the table, and there's also, I think, towards the future, options to come to a garment unfair trading practices directive, or the fashion watchdog campaign that we're doing in the UK. And it's really reaching out to policymakers, and that can be as simple as writing an email to a member of parliament, writing emails to the commission. And of course, one email in itself will not work or change the whole world, but if the same message, like we want this, we want something like this, gets consistently fed into policymakers at a given moment in time, policymakers are going to think, okay, this is a good idea. So it's also about being very consistent each time that a manufacturing association is speaking on a panel in Brussels, in Washington, in Paris, mentioning the same elements. Each time you reach out to a policymaker, always mentioning the same message. That is, in essence, in a very big nutshell, and a dumbed down version of what good lobbying and advocacy, in my opinion, would be.
This session is certainly not designed to come to a conclusion about what we're all going to go out and do now to solve this problem. This is an exploratory discussion, putting some things on the table. Patrick has outlined what is arbitration, how it works, how it might work for a producer in Asia, the sort of things you need to consider. Ben has looked at a already existing system up and running in the UK and now in Europe. And are there lessons to be learned from that? So I think there's a lot here for people to chew over, to think about, and to be considering. Are there valid potential next steps that manufacturing associations within this region, within the Asian region, could start talking about and thinking about to deal with the situation of unfair purchasing practices. I'd just like to remind everybody, if you can take time to fill out our survey, it'll take you a minute. It will help us to develop better and better webinars here. Patrick, just one last thing. I just saw a question pop up here. You already mentioned some institutions there. I think you answered this question a little bit already. You listed a bunch of Hong Kong, Switzerland, London, arbitration institutions, etc. Is there a kind of any one-stop shop that suppliers could go to, manufacturers could go to find information that is specifically targeted at manufacturers or suppliers, where they can find more information on arbitration? Is there anything else out there that could be useful for people to go and look at? Maybe Ben, you have ideas too, and then we'll have to finish on this. But first to you, Patrick.
So, well, I mean, there's the Global Arbitration Review is one of the go-to resources for arbitration practitioners. So they might want to look to that website. It really depends on what kind of information they're interested in. Yeah.
Ben, you got any ideas? Anything that sort of pops into your head about where people could go and look at that stuff?
No, I think it starts also with just a conversation with an expert because I think why would you want to look for it? It's because you probably have or think you have a potential grievance, and then need to find and navigate a landscape that might at first seem complex, but also as Patrick has explained, can also be on a number of elements quite straightforward, and just find your guide and go there. That is, of course, an absence of an ad hoc, dedicated institution. And so I've been talking a lot about specific enforcement regimes, but you also do have institutions that rather than you having to find, for example, your arbitrator, have a panel of arbitrators on call, etc. So there's all kinds of modalities possible, and I think you just need to speak with somebody who has like an overview in that, or for something that would best fit your situation.
Thanks, Ben. I just brought attendees to in the chat box. Lisa from GIZ has said if suppliers out there do want to learn more, the STTI represents 15 producer associations from 11 countries for more responsible purchasing practices. The STTI is the Sustainable Terms of Trade Initiative, and Lisa has put a link there to that, sustainabletermsoftradeinitiative.com. So click on that link if you're a supplier and you'd like to know a little bit more about some of the things that we've been discussing here, but the whole issue of arbitration and the steps that suppliers can take, I think, is in the fashion industry is in a kind of a early stage. I agree with Kim, who's just said thank you so much for this useful discussion. I think it's been I think it's been a ton of information here. I think we've covered a lot of ground. It just falls to me now to thank our two panelists, to Patrick and Ben, joined together with me for a bit of virtual applause. If you haven't done the survey, please do it. And that's it. On behalf of GIZ Fabric, I would like to thank all of you for dialing in and staying on. We value your support. Thanks again, of course, to Patrick and Ben, without whom none of this would be possible. That's all from me. Until next time, take care and stay safe. Thank you.